getting sick. This cold is going to take my voice away. Good thing we have a Fifth Amendment right to remain silent. Let's talk about it.
What is the Fifth Amendment? It's basically a legal way to tell cops to mind your business. I get cops don't always love it, but we have the right to remain silent. And just because someone gets a lawyer doesn't mean that they are in trouble. Cops can be sneaky and they can ask questions in ways that we can give responses that might incriminate us.
We're talking about Miranda rights and when cops have to read them to us so that we know what our rights are, so we don't say anything that can be incriminating and used against us in a court of law. This case centers around this dude named Ernesto Miranda. So I'll take you back to March 1963. There is an 18-year-old woman who is working at a Paramount Theater in Arizona. She gets off work late and is walking home. All of a sudden, a brown car pulls up, kidnaps her, drives her to a remote area. She is sexually assaulted and left stranded out in this desert area. She gets home, she reports to the police. She's able to give them the color of the car. And so an investigation opens up and they narrow in on this guy named Ernesto Miranda. He has a prior record for burglary and peeping Tom. So they show up at his house and they ask him if he would be willing to go down to the police station for an interview. Ernesto agrees and he goes down to the police department. He is interviewed for about 2 hours and then he starts to get tired. And at the end of the 2 hours, he eventually confesses to the kidnapping and rape. He signs a paper, and on the paper is a pre-typed statement that says that the statement was given voluntarily and that he wasn't coerced in any way. So that admission is used against him in court, and he is sentenced to like 20 to 30 years in prison for the kidnapping and sexual assault. From there, his defense attorneys argue, wait a second, that statement wasn't given voluntarily, which is a requirement of any admission or a confession. So the court was like, no, he signed the paper. So it's legit. This eventually goes all the way up to the Supreme Court, and SCOTUS argues, no, the nature of interrogations are inherently coercive. And so if officers are going to question someone about a crime where they could potentially give a statement that could be used against them in a court of law, they need to be reminded of their rights. But you have the right to remain silent. You have the right to be an attorney. I mean, you do have a right to be an attorney, but that's not what it means.
The Fifth Amendment is pretty much like your legal version of a do not disturb sign. It says, no person shall be compelled in any criminal case to be a witness against themselves. This essentially means that you don't have to talk to the police or testify if doing so could actually get you in trouble. This amendment protects you from being forced to confess or incriminate yourself. This is where people say, I plead the fifth. That means that they're being asked a question that could potentially incriminate them, meaning that they could say something that prosecutors could use against them as evidence in a crime. But it also means that the government has to play fair when trying to prove that we actually did something. That means that they can't torture us, they can't threaten us, they can't coerce us in any way. They can't put us in a tiny room and make us stay there forever until we eventually confess. Whatever we tell the police has to be voluntary, intelligent, meaning that we're not intoxicated. We have the mental capacity to understand what is going on. And we have to give a verbal, yes, we are waiving our rights, or no, I want a lawyer. It cannot be silence. There's a Supreme Court case called Salinas v. Texas in 2013. This guy, Salinas, was being accused of a double homicide. And similar to Ernesto, they asked him to come down to the police station. He provided a statement, but the second that they asked him a question about whether or not shotgun shell casings from his gun that he voluntarily gave the police would match the casings that they found at the double homicide, and Salinas just sits back and doesn't say anything. And so the cops continue to ask him questions, and he continues to talk to them, but he never gave a response to that. And so prosecutors try to use that against him, saying like, well, that silence is indication of guilt. And the defense was arguing, no, he was reserving his right to remain silent. And the Supreme Court was like, no, it needs to be verbal. People have to understand what they are being asked in terms of waiving their rights. They need to know that they have a right to an attorney. And so cops need a verbal, yes, it can't be a head nod. It needs to be on record saying, yes, I understand these rights. And yes, I would like to talk to you. Or no, I would like a lawyer. So again, you don't have to talk to the cops. If they pull you over and they're asking you for your ID, that's not what we're talking about here. when they were asking you about your potential involvement in a crime, that's what we're talking about. Here's where people get it twisted. The cops don't always have to read you your Miranda rights.
Every semester, I generally get a student that comes up to me that wants to tell me about their friend who got a DUI over the weekend. My friend got pulled over and he might have been drinking, but they didn't read him his Miranda rights. So is the case going to get thrown out? No.
There has to be a custodial interrogation occurring. And a custodial interrogation involves two requirements. One, that a person is in custody or deprived of freedom in a significant way. Essentially, it means that the person is under arrest. Scenario, they are in custody. They are in the state custody of the police. That is the first requirement. The second requirement is that the officer or detective is asking incriminating questions, meaning that the person is going through an interrogation. However, both conditions have to be met. The person has to be in custody and the officer has to be asking incriminating questions. If an officer is just asking incriminating questions, but the person is free to leave, that is not a custodial interrogation. If a person is in custody, but the officer is not asking any interrogating questions, if they're just asking you questions on scene, like what happened, and they say yes, you're not in a custodial interrogation. There's also exceptions to this as well. There are situations where officers don't have to read Miranda rights. A lot of that goes with exigent circumstances, or if there's a public safety threat, if someone is being chased and they throw a gun into the bushes into a park, they can ask the person under arrest where the gun is without reading them their Miranda rights, because that poses a public safety issue because there is a gun in a public park. Other scenarios are if an undercover officer goes into a jail or a prison, they don't have to read the person they're talking to their Miranda rights, even though they are a police officer, because the Supreme Court has ruled that when someone is in a prison or jail, that's not a coercive environment to be talking to another inmate. And so they don't necessarily have to read them their Miranda rights. In a nutshell, the Fifth Amendment allows us to not have to say anything without the presence of a lawyer or say anything that's going to be able to incriminate us in a crime. And so when we are in a custodial interrogation, those two conditions have to be met. The person is in custody and the officer is about to ask them incriminating questions. That is when Miranda rights have to be read. If someone goes through a DUI and gets arrested and the officer didn't read them the Miranda rights, it likely be because the officer wasn't asking them incriminating questions, asking you, where do you work? What do you like to do for fun? Those are not incriminating questions, but how much alcohol do you have to drink? Did you take a beer bong? Were you taking a shot? Those could potentially be incriminating questions because you are admitting to drinking while operating a motor vehicle. So again, a custodial interrogation means that the person is in custody. They are deprived of freedom in a significant way, meaning that any reasonable person would recognize that this person is not free to leave that situation. And they're being asked incriminating questions that could get them personally in trouble. That is where the Miranda rights kick in. And if you ever find yourself in that situation, first of all, let's make better life choices. And also, second, you don't have to talk to the police. If a detective of any kind is showing up to your house, they're not trying to be your friend. They may be trying to get information. I understand being a witness to a crime and cooperating with that. But if there's any indication that you could be implemented in a crime, do not talk to the police ever. I'm sorry, cops that are watching this, but Miranda's there for a reason. And so cops can't torture us into confessing to a crime. Now, when someone says, I plead the fifth, you're essentially saying, in the most polite way, I'm not going to help you build a case against me. Until next time.